Okay, we're recording.
All right, this is the case involving 6716 Chippewa Drive. It's Board of Appeals number 22-0176A. This is a regularly scheduled meeting of the Baltimore County Board of Appeals. This is a public deliberation for the case that I just identified. And I'm Joseph Evans, Brian Pennington, and Adam Sampson are here as well. And I guess we're ready to deliberate. This is a request to modify for a variance to modify the side yard requirement of 10 feet to make it, to reduce it to 5 feet in this particular instance. So does anyone have any thoughts they want to contribute?
I mean, I can start if you would like, Mr. Evans.
That'd be great. Yeah,
Okay.
thanks.
So, Mr. Cohen, I believe, and applied for this the variance for the side setback of 4 feet in lieu of 10, and I believe it was unopposed. There were no objections to any neighbors, from what I recall. And then, Mr. Cohen, so I guess the way it came to us was it was denied by the administrative law judge. Administratively, he didn't have a hearing, and I guess it was based off of his application, and he never requested a hearing, therefore wasn't able to present evidence as to the undue hardship and uniqueness. And here Mr. Cohen provided numerous pictures and testimony about the way his yard is, and to me, I think it satisfies the uniqueness factor, the way all the power lines come in, and there's a pole right in his yard, and I think that his property is certainly unique compared to the other properties in his area because of that.
He certainly could not do an extension, an addition to his house in the rear, right?
I agree.
Because of the power lines, right?
Right.
That makes his house unique, right?
Yes, I believe.
Yeah. So I know the original application was for a 4-foot variance. I thought it was modified to request a 5-foot variance. But I'm not, we'd have to check back into the documents on that, but so as to uniqueness, Mr. Sampson, do you have any views on uniqueness?
I don't know. I struggled with it. I think Mr. Pennington does a correct job in assessing it. I think the procedural history gives me less heartburn here because of the fact that there wasn't a hearing. The fact that it's not opposed, still this gentleman has to meet the requirements of uniqueness and hardship. I've struggled with it, but I can agree with Mr. Pennington's assessment, but I don't have strong conviction on it.
Okay. Well, I agree with Mr. Pennington as well, and I think his point is well taken. Now, the question of hardship is also part of the Cromwell analysis. And in this instance, the Cohens have a large family in a small house. I don't know that in and of itself satisfies the hardship requirement. I'm not sure, honestly. But under these circumstances, the fact that they they can't expand to the rear. I think that the same fact that supports uniqueness supports hardship. If that's a permissible mode of analysis here.
I mean, it isn't, isn't choosing to live in a house of one size, despite the size of one's family, a self-created hardship, and doesn't that not meet the requirement of hardship? In other words, it cannot be of one's own creation. Or am I not remembering that correctly?
I don't know, because then wouldn't every variance get denied based on that? If you move into a
No.
property and you want to do something to it, I'm just
Well, that's
trying to think out
it's
loud.
not exactly the same. It's not exactly the same thing. They've moved into a property and they've expanded their family and they want to now expand their home. They can move. I don't mean that to sound dismissive.
Right.
I think that's different from other types of hardship that are created by the uniqueness of the property. That, I mean, let me start with that first part again. Whether this meets the definition of a self-imposed hardship, maybe that's just incorrect. But am I correct that a self-imposed hardship does not meet the requirement or the criteria of hardship under Cromwell?
Well, that's correct as
I believe you're
a matter of law, right? That's correct.
Right. Okay.
Right.
So then the question here that I'm raising is just whether or not this would be
This is
self-imposed. Maybe that's not the correct terminology. Maybe that doesn't apply. That's just a thought that I had. Again, I'm not looking to go in either direction here. I'm just thinking out loud as we consider, because it was an interesting case with its history that no one in the neighborhood has opposed it or come forward, and the ALJ didn't actually have an evidentiary hearing for the reasons that Mr. Pennington said, and that's fine. There wasn't one required under the circumstances. So this gentleman comes in and he tells us some things that I didn't see from the file, and he talks about the layout of the property, the shape of it. I don't think it's unique, but the fact that it has those power lines in the pole to get to the uniqueness, as Mr. Pennington said. So the question is just whether or not he can build a carport here, or an addition.
I think it's an addition. I don't think it's a carport. I think it's an addition.
I'm sorry, he has the carport. He wants to, right? Let me see here.
Yeah. I'm not sure. I know he wants an addition.
Yeah.
I know
He has a carport
living
now.
space.
He wants to build the addition, and so,
Yeah, it is a carport there. Yeah.
He's asking you to get a variance based on a hardship, which is the fact that he wants to expand the size of his house to accommodate the size of his family.
Right. So I don't know that his family was this size when they moved in.
Well, I mean,
I don't know.
That's even more so self-imposed. I mean, I don't want to be crude, but he's expanded his family, and the question is that a self-imposed? If he's outgrown the size of his house, should he look for a more adequate home? There's no requirement that he stay in his home.
Yeah, I mean, I guess the way I look at it is sort of a but for. I mean, he would be able to, but for that power line, he would be able to have an addition out behind his house. His neighbors are certainly able to, but because of that uniqueness of the property, the power lines, I think I believe that him not being able to put an addition out back isn't because of the power lines. I believe that probably I would say it is an undue hardship.
I must say I would be reluctant to make a finding that expanding a family is legal self-created hardship. I would be troubled by that. I would be troubled by that. I wouldn't be comfortable making that finding. So I would probably then tilt in favor of what Mr. Pennington is saying. That the nature of the property, the peculiar situation with the power lines in the back satisfies both hardship and uniqueness. It's a curious situation, but I don't know that I'm looking at the matter from the ALJ just to get a sense of what was presented down below. And I do see that there was a motion for reconsideration requesting the side setback from 4 to 5 feet. So it is a 5-foot setback that is requested.
The ALJ said there must, you're looking at facts or evidence, I think. I was looking at the rationale where the ALJ says there must be a nexus between the variance requested and the unique attributes of the property. She found in this case no connection was provided, nor can any nexus be gleaned from the facts here. And I think she did have less or different facts. It wasn't as developed.
Right.
And I'm not disagreeing with ultimately where the two of you are going. I think the issue is presented about, I believe the issue is presented about the interplay of expanding one's family and creating a hardship, whether either way we rule here. If we rule where Joe is reluctant to go, then it makes it explicit for sure. By not going there, it just means that under the facts of this case, we are, as a matter of deliberation, concluding that, or at least I believe we are concluding that the expansion of one's family into a home that is not suitable to accommodate the expansion then does not create a self-imposed hardship under Cromwell. I don't know that it has to be explicitly stated, but
right. I wouldn't want to state it explicitly in either direction.
Good. Okay, then I agree with you. I was merely raising the issue, and it's a rabbit hole that I think could go down. And I do think if it's not required to go down it, then we should avoid it.
Well, I heartily agree with that. I don't really want to address a point of that sort. No.
She does find that the ALJ found. I also find that the requested variance relief is not within the spirit or intent of the BCZR, given the existing minimal side yard setbacks in this neighborhood. Well, a different issue.
That's a different issue. And, honestly, if we want to, I'm not sure where she's getting her information on the nature of that neighborhood. I mean, I'm generally familiar with that neighborhood, and I'm not specifically familiar with this particular property, but I'm generally familiar with the neighborhood. And many, many, many houses have additions because the houses are small. These are, originally built, I think, in the 50s. And they're pretty small tract houses. And the families that are living in that area tend to be large these days. And many additions are, it's a fairly routine occurrence in that neighborhood to put additions on.
Probably why there's no opposition.
That's right. That's right. Because it's a sort of an accepted feature of life in that area.
Yeah.
So.
Okay. I just wanted to raise the issue for discussion. I'm completely on board with the outcome that we're discussing.
Okay. I think what the consensus is, if I could just say it out loud, is that the variance request for a 5-foot side setback instead of a required minimum setback of 10 feet is approved because we find that under Cromwell there is both uniqueness as to the property and hardship as to the, for the homeowner. Is that a fair statement of what has emerged from our discussion?
It is.
Yes.
Okay, all right. Well, then the variance is granted and we will issue an opinion forthwith. Well, not forthwith. Nothing is ever forthwith. We will issue an opinion in due course, let me say. And Mr. Cohen will be notified in mail, by mail of the opinion when it's written.
Right.
Okay,
Thank you, gentlemen.
Thank you, Mr. Evans, for chairing.
Mr. Sampson, thank you very, very much. Well, I'll have an opportunity to speak with you a little later as well, but thank you for remarkable contributions. Not just in this case. I'm not talking about this case.
No, thank you. I appreciate it.
In general, I'm talking about. So,
All right, thank you.
okay. All right.
Have a
Take
good
care.
afternoon, Mr. Pennington. I'll see you soon, Mr. Evans.
Okay,
Take care.
thanks. Yeah.
Okay.
Bye. Bye-bye.